Welcome to the third segment of the DOJ investigation into the January 6th attack FAQs. These build, so if you missed the first two segments, please start there. Now, I'll answer the question. I have heard federal prosecutors have a high rate of conviction. Some sources are saying that the DOJ takes only slam dunk cases to trial. Is that really administering justice? Okay, well, the DOJ guidelines on when to indict or decline to indict are online. You can read them. The DOJ guidelines include this note. The attorney for the government should commence or recommend federal prosecution if he or she believes that the person's conduct constitutes a federal offense and that the admissible evidence will probably be sufficient to obtain and sustain a conviction, unless the prosecution would serve no substantial federal interest or the person is subject to effective prosecution in another jurisdiction, or there exists an adequate non-criminal alternative to prosecution. To begin with, the admissible evidence must be enough so that the prosecution will most likely obtain and sustain a conviction. Now, consider a world in which prosecutors brought charges even though they don't have enough evidence to convict. Let's say the government suspects ordinary person of a crime, but doesn't have enough evidence to prove it. The government says, well, we don't want to just bring slam dunk cases, so let's indict this person. Criminal defense trials can cost tens of thousands of dollars. Ordinary people often go bankrupt and face financial ruin defending themselves in court. An ordinary person accused of a crime faces stigma socially and professionally, and they may even lose their jobs. Let's suppose, for example, you made a mistake on your taxes. You explain to the authorities that you made a mistake. The authority or the official thinks to himself, well, this person could be lying. This person could be telling the truth. We don't only want to bring slam dunk cases, so let's go to trial and see what happens. Okay, so in this case, you would be acquitted because it was an honest mistake, but you would not be able to recoup your legal expenses in such a case. Now, let's imagine a world in which the DOJ brings hundreds of weak cases and they lose. Think of the waste of public resources. Think of the loss of credibility. How would you feel about a prosecutor who came into your town and charged 5 of your friends with crimes and all 5 were acquitted because there wasn't enough evidence? Would you say, well, it's really good that prosecutors bring cases that are not slam dunks because that's how we administer justice? No, you'd say the DOJ was staffed with incompetent hacks, and you'd be right. I suspect when people express irritation that the DOJ only brings slam dunk cases, they want the DOJ to bring weak cases against people they don't like, not themselves or their friends. The problem is that rules are rules. If you want lots of people who you don't like charged on weak evidence, you have to be prepared for lots of your friends to be charged on weak evidence, because once the guidelines change, they change for everyone. I suspect I know the source of some of these slam dunk criticisms. Here's a guess. A former federal prosecutor who says something like this was possibly the kind of prosecutor who rushed to trial without enough evidence to convict. He ended up leaving the job because his supervisors kept criticizing him for bringing cases without enough evidence to convict. His view of the matter would be the DOJ only takes slam dunk cases to trial, and that's really not administering justice. Surely you've been critical of bosses you didn't get along with. All right, next question or comment that I'll address. We need Trump convicted to keep him from running for office. Nothing stops a convicted person from running for office. Even if Trump is convicted on all 71 criminal charges currently filed against him, he would be eligible to be president. The Constitution determines how and when a person becomes president, and there is no felony conviction exception, which is a good thing because that would encourage political prosecutions. The 14th Amendment, Section 3, might apply to certain charges, but even if Trump is indicted now on those charges, a trial could be 6 months away or longer, plus appeals. Section 3 of the 14th Amendment was enacted after the Civil War, and it says that a person who rebels against the United States can't run for office. That's a possibility, but there are lots of procedural hurdles before you could get there. Also, for people clamoring for the DOJ to hurry indictments, what if the jury returns a verdict of not guilty? I thought the Kyle Rittenhouse case would cure people from thinking that an indictment equals conviction. Now I'll address another comment that I hear often. Trump has to be indicted to stop him from undermining our democracy and committing crimes. Variation. Because Merrick Garland didn't indict Trump last year, Garland is responsible for all the damage Trump has done to our democracy since then. Indicting Trump will not stop him from spewing dangerous lies and trying to undermine democracy. It may not even stop him from committing crimes. It may give him a national platform to become more effective at doing these things. On theory, we don't punish people until they're convicted, and the time between indictment and a trial can be lengthy. Under certain conditions, a person can be detained before trial, but crimes happen in jails and from jails. Variation. While Merrick Garland is doing nothing, Trump continues to spew dangerous lies. Because of the First Amendment, a person cannot be criminally prosecuted for spewing dangerous lies. On the other hand, the Garland DOJ is giving Trump special treatment by taking extra care to make sure there are no errors. My clients usually got low-level prosecutors who were more likely to screw up. I often wonder if they're the former prosecutors on TV insisting that Garland is doing it wrong. Because they screwed up, I could notch up some wins. The team of prosecutors put together to investigate these crimes consist of the best of the best. They're taking extra care to make sure they don't screw up. They're sticking closely to the rules and procedures. It may take a little longer to do it right, but they're less likely to lose later in court. Thank you for listening to segment number 3. I hope you found it helpful.